records.
What is this regarding, officer?
Immigration check. Just show me your papers and we can move on.
Under what authority are you stopping me?
My authority is not your concern. Show me your ID now.
You need reasonable suspicion to stop me.
You're not leaving until I verify your status.
Agent Daniel Denslow had been with ICE for 6 years when he made a decision in a grocery store parking lot that would cost him his career and the federal government $10.4 million. He was standing in front of a woman loading groceries into her trunk, surrounded by 3 other agents, convinced his badge made him untouchable. The woman's voice remained calm, measured, almost clinical as she cited constitutional law. Denslow heard defiance. Shoppers' phones recorded from a distance. Body cameras captured every word. What Denslow didn't know, what his arrogance wouldn't let him see, was that he wasn't detaining a random citizen. He was arguing Fourth Amendment law with a federal judge, and she was building her case against him, one violation at a time. Judge Marissa Crossman had spent 15 years on the federal bench, presiding over cases that shaped constitutional law. A Yale Law School graduate who had clerked for a Supreme Court justice, she possessed an encyclopedic knowledge of civil rights jurisprudence. Her reputation for measured temperament and incisive legal reasoning had earned her respect throughout the judicial community. On this particular afternoon, she finished her grocery shopping at a suburban supermarket, loading bags into her trunk under a cloudless sky. Families moved through the parking lot around her, the mundane rhythm of weekend errands providing a peaceful backdrop. "Ma'am, we need to see your identification." Crossman looked up to find 4 ICE agents surrounding her vehicle. Their badges caught the afternoon sun, their postures radiating authority. The lead agent, whose nameplate read Denslow, positioned himself directly behind her car, blocking any exit. 3 others flanked her vehicle from different angles. "I'm sorry. What is this regarding?" she asked, her voice steady despite her confusion. "We're conducting an immigration enforcement operation in this area," Denslow replied, his tone clipped and official. "We need to verify your citizenship status." Crossman felt the familiar weight of being reduced to assumptions, of having her presence questioned in her own community. But her judicial training immediately engaged. "Under what authority are you stopping me? Do you have reasonable suspicion that I've committed a crime?" Denslow's jaw tightened. "Ma'am, we don't need to explain our authority to you. This is a lawful immigration check. Produce your papers." "Actually," she responded, keeping her voice measured, "under the Fourth Amendment, you do need reasonable suspicion to detain me. I'm a United States citizen conducting lawful business. What specific, articulable facts led you to stop me?" The other agents exchanged glances. One of them, Agent Henson, stepped closer. "Ma'am, you're making this more difficult than it needs to be." Crossman understood exactly what was happening. These 4 agents had approached a woman loading groceries, made assumptions based on her appearance, and initiated an unconstitutional stop. They had no idea they had just made the most catastrophic mistake of their careers. The exchange that should have lasted moments stretched into minutes. Judge Crossman stood by her open trunk, grocery bags wilting in the heat, calmly citing constitutional precedent, while the agents grew increasingly frustrated. "You need reasonable suspicion under Terry v's Ohio to conduct an investigatory stop," she explained, her voice even and professional. "Detaining me requires specific, articulable facts that I've committed, am committing, or am about to commit a crime. Simply being in a parking lot isn't sufficient." Agent Denslow's frustration mounted with each legal citation. "I don't know where you learned about law, but I'm a federal agent. You need to comply with my lawful orders." "I understand you're a federal agent," Crossman replied, "but federal agents are still bound by constitutional limitations. You cannot detain someone based solely on their appearance or perceived national origin. That's established in numerous Supreme Court cases." Agent Henson moved closer, his hand resting on his belt. "Are you refusing to cooperate with a federal investigation?" "I'm asserting my constitutional rights," Crossman clarified. "There's a distinction. Am I free to go?" The question hung in the air, unanswered. Instead, Denslow pulled out his radio, speaking in codes Crossman recognized as requests for additional units. The message was clear. They intended to escalate until she capitulated. Shoppers began to notice the confrontation. A few pulled out phones, recording from a distance. Crossman was acutely aware that this encounter was being documented from multiple angles, including the agent's own body cameras. "You're being uncooperative," Henson stated. "That gives us reasonable suspicion." "Asserting constitutional rights cannot establish reasonable suspicion," Crossman countered, citing Hebel v. 6th Judicial District Court. "That principle is foundational to Fourth Amendment jurisprudence." The agents didn't recognize the case law she referenced. They saw what they wanted to see. Someone they assumed didn't belong in this neighborhood, someone they believed lacked the knowledge or resources to challenge their authority. Their certainty blinded them to the reality unfolding before them. They were arguing constitutional law with a federal judge, and every word was being recorded. 20 minutes into the encounter, the situation deteriorated further. 2 additional agents arrived, creating an intimidating presence around Crossman's vehicle. Her ice cream melted, her frozen goods thawed, but the agents showed no indication of releasing her. "Listen carefully," Agent Denslow said, his voice dropping to a threatening register. "We can do this the easy way or the hard way. But you're not leaving this parking lot until we verify your status." Agent Henson approached her driver's side door, placing his hand deliberately on the handle. "We're going to need to search your vehicle." This was the moment everything changed. This was the line they couldn't uncross. An unconstitutional search of her private property, an extended detention without any legitimate basis, and now the threat of physical restraint, all captured on their own cameras. Crossman spoke clearly, projecting her voice to ensure every recording device captured her words. "I do not consent to any search of my vehicle. I am explicitly invoking my Fourth Amendment rights against unreasonable search and seizure. I am also invoking my Fifth Amendment right to remain silent beyond stating that I am a United States citizen. Your continued detention of me without reasonable suspicion is unlawful." The crowd of onlookers grew larger. Crossman could see at least 6 people recording on their phones. She stood still, hands visible, posture non-threatening. She had prosecuted enough cases to know how quickly these situations could spiral. She would give them no excuse, no justification for escalating to physical force. "Your refusal to cooperate is suspicious," Denslow insisted. "We have the authority to investigate suspicious behavior." "Exercising constitutional rights is not suspicious behavior," Crossman replied. "That's black-letter law. Am I being detained, or am I free to go?" Again, no answer. Instead, Henson began walking around her vehicle, peering through the windows. Another agent photographed her license plate. They were creating a paper trail, documenting an encounter that had no legal foundation. Crossman felt anger rising but suppressed it. She had spent her career navigating systems designed to diminish people who looked like her. She would not give these men the satisfaction of seeing her lose composure. Instead, she documented everything mentally. Times, statements, actions. She was building her case. 30 minutes had passed. Judge Crossman stood surrounded by 6 ICE agents in a supermarket parking lot, her groceries ruined, her dignity under assault. She repeated her assertion of constitutional rights, asked again if she was being charged with any crime, and requested to speak with a supervisor. "Being uncooperative gives us reason to be suspicious," Henson stated, as if repetition would make the claim legally sound. For the 3rd time, asserting constitutional rights cannot establish reasonable suspicion, Crossman countered. The Supreme Court addressed this directly in Hebel. A person cannot be punished for refusing to comply with an unconstitutional demand. The agents didn't comprehend the depth of knowledge they were encountering. They had profiled a woman in a parking lot, assumed she was vulnerable, assumed she didn't understand her rights. They saw someone they believed didn't belong in this suburban neighborhood, someone who wouldn't have the resources or knowledge to challenge their authority. Denslow stepped closer, his voice taking on an edge. Your attitude is making this situation worse for yourself. I suggest you adjust it. Inside, Crossman recognized this interaction for what it was: racial profiling dressed in the language of law enforcement. She had been targeted for no reason other than her appearance, stopped without justification, detained without cause, and now intimidated for asserting the very rights she had spent her career defending. But she maintained her composure, making mental notes of every violation: the initial stop without reasonable suspicion, the continued detention without probable cause, the attempted search without consent or warrant, the use of intimidation tactics when she invoked constitutional protections, the implicit threat in Denslow's warning about her attitude. All of it, every constitutional breach, every procedural violation, every moment they exceeded their authority, was being documented on their own body cameras. They were creating the evidence that would dismantle their careers, and they didn't even realize it. A woman in the growing crowd called out, "Is this necessary? She's just loading groceries." An agent turned toward the crowd. "This is official business. Everyone needs to back up." Crossman said nothing, but she noted the witness. Another person willing to testify about what they observed. 35 minutes into the unlawful detention, a supervisor finally arrived. Agent Denslow briefed him immediately, framing the encounter in language designed to justify their actions. Subject is refusing to provide documentation, acting suspicious by citing obscure legal cases, and being uncooperative with federal agents conducting a lawful operation. The supervisor, whose nameplate identified him as Agent Patterson, approached Crossman with the same authoritative bearing. He had responded to a call about an uncooperative subject, and he clearly expected to resolve the situation through the force of his position. Crossman had reached her limit. 35 minutes of constitutional violations, of being surrounded and intimidated, of having her humanity reduced to a checkbox on an enforcement quota. She had given these agents every opportunity to recognize their mistake and release her. Now, she would end this herself. She spoke clearly, her judicial voice carrying across the parking lot. "My name is Marissa Crossman. I am a federal district court judge for this district. You have unlawfully detained me for over 35 minutes without reasonable suspicion or probable cause. You have violated my clearly invoked Fourth Amendment rights. You attempted an unconstitutional search of my vehicle without consent or warrant. You have subjected me to racial profiling in violation of the Equal Protection Clause. I will be filing a formal complaint with your agency and pursuing civil litigation for these violations." The supervisor's expression transformed in real time from authority to skepticism to dawning horror. He pulled out his phone, fingers moving quickly across the screen. He searched her name, pulling up the federal court website. Judge Marissa Crossman official photograph appeared, along with her biography detailing 15 years on the bench, her Yale credentials, her Supreme Court clerkship. Patterson's face was drained of color. His hand trembled slightly as he lowered the phone. He looked at his agents, then back at Crossman, understanding crystallizing. They had detained a federal judge. They had attempted to search a federal judge's vehicle. They had threatened a federal judge in a public parking lot. All of it documented on body cameras, witness recordings, and radio transmissions. "Ma'am, Judge Crossman, I apologize. There's been a misunderstanding. This conversation is over, Crossman interrupted. I am leaving now. Any attempt to stop me will constitute false imprisonment. Patterson immediately ordered his agents to step back, his voice urgent. The 6 men scrambled backward, creating a wide path for Crossman's vehicle. Their confident postures had evaporated, replaced by the body language of professionals who understood they had made a career-ending mistake. Crossman loaded the remaining groceries into her trunk without hurrying. She would not be rushed, would not appear to flee. She had committed no crime, violated no law. She closed her trunk deliberately, walked to her driver's door, and got in her vehicle. Not a single agent spoke as she started her engine and backed out of the parking space. She drove home carefully, adhering precisely to the speed limit, her hands steady on the wheel despite the adrenaline coursing through her system. Her groceries were ruined, ice cream melted, frozen goods thawed, produce wilted in the heat. $35 of food rendered inedible by constitutional violations. But the physical items were inconsequential. What mattered was the perfect evidentiary record the agents had created. The body camera footage showing the entire encounter from initiation to conclusion. The witness recordings from shoppers capturing the scene from multiple angles. The radio transmissions calling for backup to detain a woman loading groceries. All of it would become evidence. Crossman arrived home and immediately sat at her desk. While her memory remained sharp, she documented everything. The precise time the agents first approached, each statement they made, each constitutional violation, the names she had caught from their uniforms, the identification numbers on their badges, the witness who had called out from the crowd, every detail that would support her civil rights complaint. She had spent 15 years on the bench defending constitutional principles in the abstract. Now, she would defend them in the most personal way possible. These agents had profiled her, detained her, intimidated her, and violated rights she had sworn an oath to protect. They would face consequences that would ensure they never forgot that no one, regardless of their badge or their authority, stands above the Constitution. Judge Crossman filed her federal civil rights lawsuit 3 weeks later. The complaint, drafted with the precision of someone who had presided over hundreds of similar cases, was a devastating legal document. Filed under 42 U.S.C. Section 1983, it alleged Fourth Amendment violations for unlawful detention and attempted illegal search, 14th Amendment violations for racial profiling under the Equal Protection Clause, and intentional infliction of emotional distress. But the complaint's true power lay in its specificity. Crossman cited exact timestamps from the body camera footage matched to specific constitutional violations. At minute 4, the agents had extended the stop beyond any reasonable investigatory scope. At minute 7, they had ignored her explicit assertion of Fourth Amendment rights. At minute 22, Agent Henson had attempted an unconstitutional search. At minute 31, Agent Denslow had issued threats to coerce compliance. She attached transcripts of the encounter, pulled directly from the audio recordings. She included still images from witness cell phone videos showing 6 armed agents surrounding one woman in a parking lot. She provided her own contemporaneous notes, documenting her mental state during the detention. The fear, the humiliation, the recognition that she was being profiled based solely on her appearance. The case sent immediate shockwaves through federal law enforcement. News outlets across the country covered the story. Federal judge detained while loading groceries, files $15 million lawsuit. Legal analysts called it one of the most well-documented civil rights violations in recent history. Civil rights organizations filed amicus briefs supporting her case. But more damaging for the agency were the internal investigations her lawsuit triggered. The DOJ Inspector General launched a review of the unit's practices. Congressional oversight committees demanded testimony. Investigators discovered a pattern of constitutional violations. This ICE unit had been conducting area operations based on demographics rather than specific intelligence, targeting individuals through racial profiling and using intimidation tactics when questioned about their authority. Agent Denslow's personnel file revealed previous complaints of aggressive behavior. Agent Henson had failed constitutional law assessments during training. The unit had been operating with minimal supervision, conducting stops without proper legal foundations. Judge Crossman's case had exposed systematic misconduct, and the institution faced a reckoning. The lawsuit proceeded through discovery, and with each deposition, the government's position weakened. Agent Denslow testified that he had stopped Crossman because she matched the demographic profile of individuals they were targeting, an admission of racial profiling that his attorney visibly winced at hearing. Agent Henson claimed he had reasonable suspicion but couldn't articulate specific facts beyond Crossman's suspicious behavior of asserting her rights. The body camera footage, played in full during depositions, was devastating. It showed Judge Crossman standing calmly by her vehicle, methodically citing constitutional law, while agents escalated without justification. It captured Denslow's threatening statements, Henson's attempted search, and the extended detention despite Crossman's repeated questions about whether she was free to go. Witness depositions corroborated Crossman's account. Shoppers described watching federal agents surround a woman who was simply loading groceries. One witness testified that it looked like they were treating her like a criminal for no reason. Another stated they recorded the incident because something felt wrong about the whole thing. Internal communications revealed that supervisors had encouraged aggressive tactics during these operations, prioritizing enforcement numbers over constitutional compliance. The unit had conducted dozens of similar stops, though none had targeted someone with Crossman legal knowledge and platform. After 8 months of mounting pressure, facing a trial that would be a public relations catastrophe and likely result in even higher damages, the federal government agreed to settle. The settlement was $10.4 million, one of the largest civil rights settlements for immigration enforcement misconduct. But Crossman insisted on more than monetary compensation. The settlement agreement included mandatory policy reforms, comprehensive constitutional training for all agents with annual recertification requirements, strengthened body camera review procedures with civilian oversight, community advisory boards to monitor enforcement practices, and suspension of area operations unless supported by specific intelligence rather than demographic profiles. These institutional changes became part of the binding settlement agreement, ensuring that her experience would result in systemic reform. The individual consequences for the agents were severe and immediate. Agent Denslow, whose threatening statements and leadership of the unlawful detention had been captured on camera, was terminated from federal service. The agency revoked his federal law enforcement certification, effectively ending any possibility of working in law enforcement again. His personnel file, now marked with a civil rights violation, ensured no other agency would hire him. Agent Henson and the 2 other agents who had participated directly in the stop were suspended without pay for 6 months. Upon their return, they were reassigned to administrative desk positions processing paperwork, a dramatic demotion from field operations. Facing professional stigma, no path to advancement, and the knowledge that their names would forever be associated with constitutional violations, all 3 resigned within 18 months. Supervisor Patterson, who had arrived late but failed to de-escalate and had initially attempted to justify his agent's actions, received formal discipline and was demoted 2 ranks. His career trajectory, once promising, was permanently derailed. The case became required training material in federal law enforcement academies nationwide. New recruits watched the body camera footage, studied the constitutional violations, and learned the consequences of racial profiling and abuse of authority. Legal instructors used the case to teach the practical application of Fourth Amendment standards. The title of the training module was blunt: When Assumptions Cost Careers. Judge Crossman returned to the bench with her reputation not just intact, but enhanced. She had demonstrated that knowledge of constitutional law wasn't merely academic. It was a shield against tyranny. She donated $2 million from her settlement to organizations providing legal defense for immigrant communities and civil rights advocacy groups working to reform law enforcement practices. The grocery store parking lot where the incident occurred became, ironically, a symbol. Local civil rights organizations held an annual event there, educating community members about their constitutional rights during law enforcement encounters. The 4 agents who had approached Judge Marissa Crossman that afternoon had seen a woman loading groceries and made assumptions based on her appearance. They had believed their badges granted them authority without accountability. They discovered, too late, that they had targeted someone who understood the Constitution better than they did, and who possessed the platform, the determination, and the legal expertise to ensure they faced consequences for violating it. The Constitution, Crossman had proven, protects everyone equally, and those who abuse power under color of authority will be held accountable, regardless of their position or their certainty in their own righteousness. Justice, however delayed by 35 minutes in a parking lot, had been served.